Okay, just want to note that Sherman rolled his eyes when he said the word attorney, and I take note of that. Unfortunately, we are a big part of this process. I do want to just give you a basic overview of what compensated surrogacy is from a legal standpoint, because it's all state regulated. There are currently 5 states, New York being one of them, New Jersey also being one of them, Louisiana, Michigan, and Washington state, where compensated surrogacy is illegal. It's prohibited by law. Now, after the last election, Washington went all Democratic in the House and the Senate and executive branch. So there's hope that Washington's laws are going to change. There's even more hope that New Jersey's laws are going to change because they've actually had a surrogacy statute pass the House and the Senate, but Governor Christie refused to sign it. Now that there's a Democratic governor coming into New Jersey, there's real hope. In New York, unfortunately, if anybody was here last year, we had Brad Hoylman speak. He's a state senator, and he is the sponsor of an act called the Child Parent Security Act. It is New York law that would legalize compensated surrogacy. It's been stuck in Senate committee for 4 years. Last year was the first year it made it out of Senate committee. It's still stuck. Until we have a major change in New York, we are going to be stuck with the statute that prohibits compensated surrogacy. Altruistic surrogacy or compassionate surrogacy is legal. There are some restrictions in the law about it. You cannot compensate your surrogate, though, in New York. And New York's law was a knee-jerk reaction to a case called the Baby M case, which happened in 1986 in New Jersey, where a traditional surrogate, that means a surrogate who's also the biological parent of the child she gave birth to, won parental rights to the child that she gave birth to. New York freaked out, and we enacted the current statutory prohibition. So, that doesn't mean that New York couples can't have children through compensated surrogacy. It just means that our contracts can't be enforced in a New York court. So our surrogates come from outside. The good news is that the providers that we have here today are located all around the country, and the surrogates are located all around the country. The specific law that is going to apply to you and your journey is the law of the state where the surrogate gives birth, most of the time where she lives. My surrogate lived on the southern border of Virginia and North Carolina, but she wanted to give birth in North Carolina at the hospital where she had given birth to all of her other children. So in our surrogacy contract, which I'm going to talk about in a second, we had the laws of both Virginia and North Carolina in that contract, just in case something happened and she gave birth in Virginia. So let me tell you a little bit about, now you understand the jurisdictional aspect. Let me tell you about what the reality of the legal steps are. The first time that you're going to be dealing with a contract, a legal contract, is if you're working with an agency. You're going to have a contract with them. This, oddly enough, is also the only time in the process where you're not going to be represented by counsel. The agency contract is going to spell out the responsibilities that you have to the agency, providing them with accurate and truthful information, funding your escrow account, all of the logistical aspects, and what the agency's obligations are to you, to providing counsel throughout the process, securing counsel for the surrogate mother or the egg donor if applicable, and addressing parental establishment at the end of the process. So the strange thing also about New York law is that it not only prohibits compensated surrogacy, it also prohibits attorneys from counseling anyone regarding a compensated surrogacy agreement. So you couldn't call me and say, can you take a look at this agreement for me and let me know if it's, if it's okay, unfortunately. But again, that agency agreement is the only time you're going to be unrepresented. If you sign with an agency, and we're going to go through the difference in a minute between agency and independent journeys, if you go with an agency, the next contracts that you are going to see are going to be either with your gestational carrier or your egg donor or both. And your agency is going to represent you in that negotiation. Again, the surrogacy agreements try to provide for every possible outcome that can happen in a surrogacy journey. There are clauses about medical dangers to the surrogate mother. There are things that are kind of scary, and Michelle, as a surrogate mother, can speak to her reaction to signing those contracts, because you really realize that there is a risk involved and you understand the compensation on a much deeper level. But the agreements also provide for one thing that's very controversial, which is a selective termination provision, and that is if the intended parents choose for a medical reason to terminate a pregnancy. And ostensibly, both the gestational carrier and the IPs get on the same page. And it's important that they're on the same page if, God forbid, something were to happen like that. The reality is there is no court in America that's going to enforce a surrogate mother's having any kind of termination of a pregnancy. But if something does happen, at least the surrogate mother and the IPs can say they worked through the thought processes, and there is something on paper that denotes that. The surrogacy agreements are going to have the law of the state where the surrogate plans on giving birth, and it's also going to provide for what happens afterwards, because, as I said, each state has a different law around surrogacy. So if your state, there's certain states that provide for something called pre-birth orders. There's certain states that provide for something called post-birth orders. And this is all about establishing parental rights for the non-genetically related father. Because there's always going to be I think when we started off many years ago, when we were doing this, we were told at one point that we didn't have to identify who the genetic father was. We could do a sperm shake and, just fertilize an egg and see what happened. But the truth is, from a legal perspective, you do have to identify who the genetically related father is, because you have to secure the parental rights of the non-genetically related father, usually after the process. There's two ways of doing this. And some people opt for doing both of these. When my husband and I went through the process, we had to do both. First is to get a pre-birth order or a post-birth order. That is a court order that terminates the rights of the surrogate mother and her husband in many situations, and also in some situations terminates the rights of the egg donor. That will leave one legal father. There are some states, that's the genetically related father, there are some states that will now put the non-genetically related father, establish parental rights through this pre-birth order. And by pre-birth order, that means it's all done before the child is born. So you have the order when you go to the hospital when your surrogate is giving birth. You give it to the administrative person, do a dry run first, make sure that they know what's coming, and then they will have you both put on the birth certificate. Now the question is, does a birth certificate create legal rights? A birth certificate is an administerial document. You need to have some kind of court order that backs it up. So that's a pre-birth order or a post-birth order. Okay? Some couples choose also to have what's called a second or step-parent adoption afterwards. That would take place in your home state. Okay? That's something that I do a lot. So second-parent adoptions are a more rigorous process. They're a more invasive process, but they also produce a court order that is subject to full faith and credit around the country. Now, this is probably one of the most controversial things that I deal with as an attorney working in surrogacy. If you have a pre-birth order, do you have to have a second parent adoption? Because really, the answer is you shouldn't. It's a court order. But each state has a different means of producing a pre-birth order or a post-birth order. And unfortunately, when couples break up, if there's acrimony, where I have seen a number of very expensive litigations happen, is around the efficacy or validity of pre-birth orders in a different state than they were generated in. Again, these are state-produced, and there's some states that don't produce them. There's some states that will only put a genetically related father on through a pre-birth order. There's some states that will look at your marital status and create a marital presumption to put the non-genetically related parent on. I guess the end point of what I'm trying to say is you need to talk to an attorney in your home state as well as your agency about what's going on in establishing parental rights for the non-genetically related father. Okay? In this process, your surrogate's going to have a separate attorney, you're going to have your agency attorney, and then you may have a separate attorney, you probably will, for parental establishment, certainly if you do it through second parent adoption, but also if you do it through pre- or post-birth order. Okay? Now I want to speak a little bit about the legal steps in Canada, because Canada is a little different. Canada is becoming sort of the new frontier for surrogacy. However, in Canada, compensated surrogacy is illegal. Reimbursement for, basically, a gestational carrier is entitled to reimbursement only, not for compensation. So reimbursement includes lost wages, travel, medical expenses, other pregnancy-related out-of-pocket expenses, food and clothing, and it usually ends up to amount to a smaller amount than what a compensation package is in the United States. However, one of the things that we are learning in this process is that it isn't really defined what reimbursement is specifically. And I think agencies and lawyers in Canada are working now toward defining that in their contracts and in their packages. However, basically compensation is illegal. And in Quebec, no surrogacy arrangement, even reimbursement. It's a provincial issue there, like New York. Quebec is the New York of Canada, except you can't even have a compassionate surrogacy in Quebec. The most important thing that I can say about the legal aspects of a Canadian surrogacy journey are the establishment of parental rights for the non-genetically related parent, because they're doing something I know in Ontario where there is a ministerial process that's very easy that can get the non-genetically related parent on the birth certificate. And it's meant to make the process streamlined and fast and less expensive. But it's not a court order. So technically, in the United States, it may not be subject to full faith and credit. The good news is you can ask, and I strongly suggest that you make sure that if you do go to Canada for a surrogacy journey, you have your attorney there create parental rights through a court order process, not an ministerial process, because they do have sort of the Canadian version of pre-birth orders there as well.